We're going live. We're going live. All right. What's going on, people? All right. I'm about to say this is Nate the Lawyer's channel, but this is not. This is Laid Back Law. How's everybody doing today? We're going to wait for some people to get in. I got a hard cutoff at in like an hour. So I wanted to start this up. I bet Nate is hosting. Yes, you bet right. When you see me on the screen, you say, I bet Nate is hosting. I am here. I am hosting. What are you going to say? So what's going on? But how is everybody doing out there today? It seems like we have a nice group of people coming in. What's going on, guys? Sup. It's always great to see everybody. Yes. Eric is in California. So, we got our first guest. What's going on, Mike? How's everything going?
Nate, what's going on, man?
Nothing much, just starting to warm the crowd up and get into the madness. First, I want to thank all of you out there in the world who joined me last night for the Tiffany Hinyard Madness. I think we had 12 or 13,000 people watching live. Thank you, guys. Whoa. I don't know why everybody loves that crazy story, but that story was hot on fire last night. So thank you guys for watching it. How's everything going with you, Mike? What's going on? I haven't seen you in a while.
Yeah, man, been a little bit. Norm and I have sort of disbanded what Law Pod Daily Law and Legitimacy was in its prior form. So I've actually been sort of trying to figure out how to live life in a way that's different from the last basically 3 years. So it's been an exercise, but overall staying quite busy. Got a little one on the way due in October. So plenty to keep my hands full. Never idle.
That's amazing, man. That's amazing. I always tell my wife I got 2 kids. I got one in a possible, like a bad spades hand.
One in a possible, yeah.
One in a possible.
How many books you got, right?
Yeah, she doesn't look too close like me. I'm like, it's a strong possible, but we'll know this.
Took me back to the high school lunch table there, man. Wow, that's funny.
Oh my God. But yeah, bro. So it's great, and I gotta have you on my channel. We got to do something together. My stories are crazy. I cover the crazy stories. So if you don't mind covering crazy legal stories, you have an open invitation to always come on and
oh man, that'd be an honor to join you, man. And I owe you a lot for the more recent success this year we had in kind of navigating sort of the LawTube world and how to sort of commercialize that channel. So all praises to you, and you deserve every bit of the success you're enjoying right now, man. Love to hear that you're getting so many people live. That's awesome.
Thank you so much, man. Thank you so much. I really appreciate it. Hold on. I got somebody from Dalton, Illinois calling me. Let me see what this is. Give me 1 second. I'm just going to mute for a second. Yeah, that was my contact from Dalton, Illinois, because I'm involved in that. So I got to call that person back so we can find out. But we got a lot going on. All right. So.
And I'll probably be hopping out at probably 12:40, 12:45 because I've got a day job as well, man. But I'm here, definitely interested in the just sanguinis part of this discussion. So we'll start talking about that in a few, I'm sure.
Okay. Well, all right. So first, let's the first story. Because I was sending you the stories as I was finding them because I thought I wasn't sure if I should find the stories, but then I was like, I'll find some this morning. The first story, which is one I didn't send you, but it's an interesting story. So you remember Jesse Smollett, right? Everybody remembers Jesse.
Yeah.
Now, we thought that was a one-off event. We thought Jesse Smollett was a one-off event, but we have now another Democrat who's just been arrested for impersonating a Trump supporter and committing fake hate crimes against himself.
I think I saw this.
Check this out. This story is insane. So you get to watch it with the crowd. It's about 53 seconds, but this is the story from Texas.
More new information tonight on this story: the arrest of a candidate for the Fort Bend County Commissioner's Court.
Yeah, police say Carroll Patel created a fake social media account, then used it to make racist attacks against himself.
Did this guy realize they're gonna get him? This is crazy.
Stop hitting yourself, bro.
Oh my God. And it goes on. This is crazy.
It's facing a felony count of online impersonation. In newly obtained court documents, authorities allege Patel stole a Needville man's photo, used it to set up his fake Facebook persona for a man called Antonio Scallywag.
All right, you got to pause. That's
I gotta pause it.
is that
Antonio
like
Scallywag?
is that sort of like a contrived reference to Antonin Scalia, the late great? What in the world? It gets deeper.
He couldn't find a better name than Antonio Scallywag.
I take exception to that.
You take exception to that? If you're a Trump supporter, Antonio Scallywag is a good name.
Yeah.
This guy. It's not even over. It's not even over. Check this
And
out.
according to documents, the scheme was uncovered after Patel sent out a press release highlighting racist attacks targeting him and his campaign. Of course, now police believe some of those attacks were fabricated by Patel himself. Tonight, he's out on bond. We've reached out to him multiple times for comment. So far, we have not heard back.
More
Now-
new information.
Now, you would think that was it about this story. You think, okay, so they arrested him. He's going to trial for impersonating a Trump supporter. You would think that's all to the story. But there's more. So he gets arrested, right? Goes and blah, blah, blah. Then
Search warrant
he
filed
gets
by
arrested again because he's impersonating the judge overseeing his case. I am not joking. This is like real. This guy is, and it's, oh yeah, and just so everybody understands who this guy is, he was a White House aide. So he worked for the Biden administration. He was appointed by Biden to be a White House aide. And also he worked for the Justice Department in the public integrity section of the Justice Department. So this guy is connected all the way to the White House. Check this out.
The Fort Bend County candidate who was charged last month for allegedly faking racist social media posts against himself is under investigation again for a similar crime.
Yeah, a new search warrant filed by investigators this week claims that he impersonated a district judge on Facebook. In fact, it's the one who was initially assigned to preside over his first case.
ABC 13's Rosie Nguyen is in Fort Bend County with how this was uncovered.
Thurl Patel is running as a challenger for the Precinct 3 Commissioner seat here at the Fort Bend County Courthouse. Investigators with the District Attorney's Office believes that during the course of his campaign, he has been impersonating other people using fake social media accounts.
New search warrant documents reveal that Thurl Patel may face a second charge for online impersonation. Investigators first arrested him back on June 12th after looking into a collage he posted on his campaign page containing supposed racist social media comments that were directed against him. They linked one of those.
So now the way they caught this guy, Antonio Scallywag.
And how long do you know how long this stuff goes back? I mean, how long when did he create the account? Do we have any of that info?
So from what I'm hearing, it was like it's like a 6-month thing. He created the account was created. So the full story about this, let me take this down. So the full story about this is that he's running for a county commissioner seat in Texas. He then is not, but the commissioner who's been there is a Republican. It's Ruby Red, Texas. Republican, he's been there for like 40 years. So he started saying that, hey, I'm getting racist attacks online. He creates this account. And the Republican in that seat was like, yo, he's like, this account seems new. And I think I know it. I've seen it around before. But he was like, he asked the local district attorney to investigate. He said, can you investigate this? He's like, I don't want the guy being harassed because he's whatever, even if it's my supporter. This is the Republican who did this. Sure. So he made a complaint with the district attorney's office. And then the district attorney's office went and looked up and subpoenaed Google for all the account information. The account stuff from Antonio Scallywag, this idiot forgot to wipe the account. So his bank account information was on there. His name, his address, his email, banking, like everything was associated with his account. So they were like, you're Antonio Scallywag. And now they're finding out that he was also impersonating the judge in the case. Well, after he got arrested and indicted, then they found out that the judge who was ruling on his case, he then goes on Facebook and starts impersonating that judge. So this is a guy. Remember, this is a Democrat who's working for the Justice Department in the public integrity section of the Justice Department. So this is crazy.
I think I from time to time listen to Adam Carolla. I'm not sure how familiar you are with ACS and that kind of stuff. And his position on this, which I think is really great, is that demand far outstrips supply when it comes to this sort of stuff. So I think it's interesting that this is sort of proof positive, obviously just one data point, but interesting nonetheless. I am wondering, as a corollary here, what's the standards around involuntary commitment? This sort of stuff needs to be investigated at sort of a at that sort of level, right? I mean, we've all got our small little corner of the internet and our own sandboxes, so to speak, but some of us are doing some interesting, like more interesting stuff than others with our corners of the internet. I think this is wild, man.
Yeah, it is insane. From now on, I'm gonna change my name to Antonio Scallywag. Like how he couldn't pick just a regular name. What the hell is Antonio Scallywag?
It'd been better if he had just gone with Antonin, because that's what he wanted to be. You know what I mean? Say Antonin.
But I think you're right. I think since there is no, well, obviously racism exists, but I think he couldn't find it, and so you just make it up. And this is Jussie Smollett, and I always find it interesting too. It always goes only one way. You don't see it going the other way. You don't really see Republicans pretending to be Democrats and committing hate crimes against themselves. It's always the opposite way because it plays into the narrative. You know what I mean?
Well, I'm reminded of a couple of things. One is the story about racist graffiti appearing on LeBron James's gate at his home some years ago, and no evidence was ever produced as to the source of that or the veracity of the fact that may have been some sort of hate crime. No arrests were made, no investigations turned up any persons of interest. And so, one need not venture very far to perhaps think that LeBron is not the most trustworthy person in the world, regardless of what you think about his on-court talents. The other thing I think about is this push that we've seen as of late, and it's more of a bipartisan push, I might add, but just to kind of scale the conversation a little bit, is the sort of hate speech exception to the First Amendment, the likelihood that we will in our lifetime see yet another exception born under that broad First Amendment protection of freedom of association, freedom of expression, etc., as it pertains to hate speech as uttered. And I think we're all aware of things going on across the pond in London and England more broadly. But this is interesting nonetheless, because it appears as though perhaps that whole story, at least from the left, from the political left of our paradigm, is fairly, I guess, arbitraged, right? That these, I think we not very long ago, Garland wrote his op-ed in, I believe it was the Washington Post, talking about, how tempers needed to cool unto, calls for violence against judges and this politically motivated online hate-filled rhetoric, da-da-da-da-da-da-da. And I remember reading that at the time thinking, how disingenuous of a piece that was, number one, for WAPO to give the platform to our attorney general in that manner, but also the fact that, this predated the assassination attempt on Trump, but it seemed reasonably calculated that if there were a credible online threat as to, calls for violence or hate speech or whatever, that it was not coming from the political right. And if there were, we don't have to guess about these things. We've talked about Supreme Court justices. I know that we have other stories today that we'll talk about with respect to SCOTUS. But, during the confirmation, during the Trump era of several of those justices, there were calls for violence. There were arrests made with, firearms in hand or in possession of some of these people. So I think that a lot of what we're talking about here, it's interesting that we as a society can be so siloed, and that this gentleman made a political calculation that this was in his interest politically, right, to do this thing because it would give him sort of a mantle upon which to stand to say, I am a victim of, all of this stuff that we claim is real coming from the hateful, online right kind of. Yeah. So, that is the total inversion of, I think, what the political reality is in the country, the cultural reality in the country. So, while we can laugh at how ridiculous the story is, had he been better at the fraud, it would have gone
People would
unabated.
believe it. People
Right?
would have believed it. And
True.
and because but I think people would have believed it because people want to believe it. See, I think we live in the type of America today where Bakari Sellers went on Bill Maher and he said, hey, it's just as bad today as it is in 1950 Alabama.
I
And
don't even know what that
said,
means.
well, in 1950 Alabama, we had the black codes and,
Sure.
segregation and stuff like that.
Sure.
I don't think any intelligent person would believe that it is just as bad today in America than it was in 1950 Alabama. That is a ridiculous statement. And what I do, and the reason why it offends me is because it ignores the progress that we've made from that particular point, right? It's almost saying that all of the progress that we've made to get to this point where he can say something like that and not realize all the legislation from the civil rights legislation to even affirmative action and going through that process, right? 50 years of affirmative action and trying to right the wrongs of the past to get to this point where, I'll say if you go back 10 years ago, if, like, for instance, when I went to law school, you got extra, I don't want to say credit, but it was, if I was being black with an LSAT score, an average LSAT score, got me into schools where my white counterparts wouldn't even be able to apply to. That was because they were trying to right the wrongs of the past. And to an extent, I understand that. But to forget that right now, if you're black in America, you're living at the best time ever in this nation's history to be living in this country and be black, and to pretend that's not the case, I think is a disservice to the country, and I think is an unreasonable position. My God, we even have a black woman running for president. We had a black president during this time. So this is not 1950s Alabama. But as long as saying stuff like that get you money, get you sympathy, and get you votes, like we're seeing with this guy, people are going to continue to push this narrative, and we got to continue to push back.
Well, and then, it's reasonably calculated to yield legislative changes as well. And that's truly the issue. I mean, we're entering this territory where Congress and state legislatures are put in a position to pass law, to propose laws, pass laws, to limit and restrict certain behaviors online and in person based on false realities, right?
Yes.
So these, again, the reason I think that it's, particularly important that we highlight how ludicrous this is because on balance, all it took was the counterpart in that election to take one look at the history of that account, because obviously they're doing oppo research, right? Yeah. Like what has he said in his past that we can perhaps dig up to cross-examine his public-facing positions or what he's doing now. So it was probably garden variety diligence that they were doing that yielded this question mark of, wait a minute, you just appeared online 6 months ago. Your internet life is limited to a chronology of 6 months. That is patently ridiculous on its face. And that's why I said, had he been better at this, it would have gone forth unabated. But the logical extreme of all of this is that it is likely to have yielded something in the future, which would embody some sort of restriction on free speech in another vector that we're watching all over the country right now. It's like, some sort of like a petri dish that we're playing with.
Yes, no, I totally agree. And I think, but now, especially with at this point in time where we're doing this whole thing when it comes to the election, I think it's just going to get worse, because I think Democrats, and it's unfortunate, I think Democrats need to make Republicans out to be racist to win, because I think if they don't have that narrative, it makes it harder for them to win. And I think that sympathy makes it so. So I don't think that goes away. But I go ahead.
Not to borrow too much of a sports reference, but I mean, that is the offense that they're running, right? It's sort of like saying, hey, yeah, we run a spread offense. Okay. Yeah. And so you reasonably expect that the spread offense is going to be pass heavy, and the pass heavy in this context is identify racial animus and attack that. Right.
Yes. Hey, Joe, what's up, baby? You just missed The thing about the guy who's arrested for pretending to be a Trump supporter.
Joe, are you auditioning for Selling Manhattan? What is that show on Netflix right now? Nice skyline, luxury loft.
Thank you. I am trying out different looks. I usually use this one nighttime. I have I'm on locations. I don't have my normal background behind me.
Oh, all right.
So that's why I have an array. Well, as much of an array as StreamYard lets me engage in, but pretty much I got this one.
Oh, sick.
That one's standard. Yeah, this one's pretty good, right?
What are your commissions on these?
The first one you had was really good. Yeah, I like the first one you had.
This one's really nice. Oh, and then because I'm always joking about how there's continual jokes about my diggers who are my local followers. I call them diggers, being in tunnels. So I have this one. I have this one also. The Jew in the tunnel. There you go.
They still talking about the tunnels in Williamsburg. They still talking.
Yeah. So
that was a year ago, but it's still a funny story though. It's still a great story. Yeah. You know what? But since now Joe is here, we can move on to. All right. So you guys remember the Trump E. Jean Carroll case, right?
Mm-hmm.
So just to recap for the people who don't know what's going on. So E. Jean Carroll said Trump had blanked her, and I'm using blank instead of the word with the R. So she said he blanked her. She said he blanked her. They went to trial, and it was a civil trial. Now, during that civil trial, the jury specifically came back and said, well, we don't find Trump liable for blank, but we find him liable for sexual abuse. And the sexual abuse is slapping someone's personal areas, right? Private areas, or
just to be clear, in order for it legally to rise to a level where it's labeled that it earns the R word rather than just being assault, there has to be penetration, right?
Yes,
that's the
carnal knowledge, right? Yeah.
I'm saying is there actually has to be penetration, and it doesn't have to be genital penetration. It could be any part of any
foreign object or something.
Any kind of, and it could be any part of your body or any foreign object that would be penetrating. That's when it rises to the level under the law as far as being classified as earning YouTube's dreaded R word. So,
but I want to be very clear. She said he penetrated blank. That was her argument.
Right.
Yeah. So just to be clear, the jury rejected that, said that didn't, we're not finding him liable for this.
Zero penetration.
Zero.
Mouth hugs.
Mouth hugs. So then, then Trump, after that, goes out and says, well, I didn't blank her, and she's lying. I didn't blank her. So then she sues Trump again for defamation, saying, no, he did blank me, and the jury said he did. So then she sues again. They go back to court, and Judge Kaplan in New York, faced with this dilemma, like, hey, the jury said he didn't do it. The judge says, well, we're going to pass a judgment in her favor, and she got paid still like $83 million, saying, even though the jury specifically said he didn't blank her, they really meant he blanked her under a colloquial understanding of the word blank. So, go ahead.
Yeah, and I don't even think that colloquially people would ever refer to, let's say, anything that doesn't involve penetration. I don't think anyone would ever refer to that as the R word, right? I mean, if you think about, I guess some people might refer to, touching genitalia in that way, but I think that is not mainstream perception. That when they hear the R word, that she used it, that he said he never did, they think he's talking about something beyond kissing or using his mouth in a way that would be inappropriate with someone you don't have an intimate relationship with, right?
Yes. But so just because of the recap, Trump was not found liable for blank. The judge then says, well, even though the jury didn't find you liable for blank, we're going to say that they actually did find you liable for blank because in a colloquial meaning, you blanked her. So Trump now has to pay millions of dollars to her. So George Stephanopoulos then is interviewing Representative Nancy Mace on ABC. And he says, Trump was found liable for blank. and a jury found him liable for blank. So Trump is looking at this, and his team is like, "What are you talking about? The jury specifically didn't find me liable for blank, even though I'm paying E.G. and Carroll millions of dollars because the judge said he did." So Trump team sues. Now, everybody thought Trump team had no argument because you literally had a judge saying, "Well, colloquially, it's true." Now, the new judge, this federal judge, says, "Not so fast. ABC is not just a colloquial organization. This is a news media organization. They have lawyers, they have his team. And when someone specifically says Trump was found liable for blank, and the jury said he wasn't found liable for blank, you have defamed Trump, and we're going to trial." So now, as you can see here, Trump has survived a motion to dismiss against ABC and is now going to trial because George Stephanopoulos said he was found liable for blank. So we are in this weird situation where if Trump says he didn't blank her, he gets sued for millions of dollars for defamation. But now if anybody else says that Trump was found liable for blanking her, we have to pay Trump for defamation.
It's really
doesn't make any sense.
And what really makes no sense about that defamation thing, and I can't imagine how this survives appeal, is because when he says, he's the one who's saying the phrase. He said, "I never art her," right?
Yes.
So if he's saying it, why should people assume that when he's saying it, he's saying it in a colloquial term rather than saying it in the legal term? Even if some people do say it that way, right? So if anything, these decisions should be exactly the opposite, right? That Trump should be able to say, "I was not talking in a colloquial term," and Stephanopoulos kind of should be able to say, "I was talking in a colloquial term." You would think the person should be able to define how they're actually speaking. That would be a much more logical contradiction that could arise than this, where it's like, no, we're looking at how the listener is going to interpret what you're saying rather than how the speaker is interpreting his own words. So, I mean, and that's essentially what's happening here, right? I mean, that the Kaplan is saying, well, we're going to look at how your audience perceived your words rather than you actually being technically accurate. And again, this judge is saying we're looking at how your audience views you. They're going to view you differently than the way Trump's audience would view him. People look at Trump and they view his audience. They view him as speaking colloquially. Some people, I guess, the people who still watch Stephanopoulos take him seriously and think that he's talking in a more of a legal fashion, and that's why it could be something that would be defamatory. No one realized when the jury came back with that initial stupid decision of we think 30 years ago that he didn't do this level, but he did that level, which was the most ridiculous finding by a jury in the world. And now look at the genesis as what's unfolded. 2 more lawsuits have unfolded because they tried splitting the baby that way, right?
Yeah. What do you think, Mike?
Well, I don't know. You asked, like, you guys remember the E.G. and Carroll stuff? And it's like, no. That was the call of the question. Do you remember? No, I don't.
That was
the call of the question.
It's been memory hold. But it is, no, point made. But I do think that there's a certain, I don't know, ambivalence that I have right now about about this story in general, just because it's emblematic, again, of sort of the larger picture that we're having to look at right now, which is depending on what silo you find yourself in, you want certain things to be true. You know, there is a huge cohort of Americans that want, that want ABC to be vindicated here, right? And on the other hand, there's a huge cohort which largely are, in my estimation, are watching your respective shows and trying to figure out the merits of all of what's going on, that understand exactly what you just said, Joe, which is that these are very counterintuitive decisions, but the counterintuitive decision led to the second one, right?
Yes, precisely.
I think Joe said it really, really well. The fact that these decisions should be exactly opposite, the only way that they make sense. Because now Trump is literally in a position where he can't say he blanked her. But if anybody else says that he blanked her, he's going to get paid from Stephanopoulos. But then if he says, yeah, I did, you see, I didn't blank her, look at the Stephanopoulos case, she can sue him for defamation again. So it's like none of this makes sense. None of this is consistent. Hopefully some appeals court will look at this and say, this is ridiculous. We need to stop all this. But
Well,
it doesn't seem like it's going to happen.
Joe, so you were talking about the, I guess, some sort of framework that the courts were using to analyze this. So in terms of audience and the subjective perception of.
I just came up with it now. I was literally talking out of my butt, but it's the most logical way of trying to interpret, trying to give legitimacy to these court rulings.
Yeah.
But,
Okay. I misunderstood.
I'm not married to the position. I'm simply saying if you want to try and find some sort of legitimacy here and say that there's not an inconsistency, that's the way you would do it.
But just to be clear though, as from the legal perspective, the audience who you're speaking to matters in defamation too, though. Like the audience matters, and the context of what you're saying matters. So in this particular case, if you're, because it can be a specialized field, like you're talking about medicine or something, using terms that are only recognized in that field where colloquially people went. So that's where I think you can make the argument that the audience does matter. I think Tucker Carlson's case against the Playboy Playmate, when he said that she was extorting Trump, they removed that because they said, number one, he's an opinion show. Number two, the audience, a reasonable person in the audience wouldn't be expecting this to be a legal analysis of this. They would expect it to be an opinion show. So in certain instances, it is the audience who you're trying to figure out. And the intent of the person saying it is less relevant than the audience who's receiving it.
Well, and I'm blanking on the case or cases, but it seems like during the Trump presidency, one of the major networks prevailed in a defamation action based on a finding from the court that they were primarily an entertainment platform. And
Rachel Maddow,
yeah, right, and that there was no reasonable expectation of pursuing the truth. Therefore, I mean, that's sort of a proposition that flows from saying it's primarily or predominantly for purposes of entertainment. It shouldn't be taken. So it's just, again, sort of that blend of take us seriously. We are, we assume the mantle of, science and this and that, except for when we say something that's categorically false, in which case you shouldn't have taken us seriously at the beginning because we're here to drive ratings.
Well, that it's funny because that same ruling was both Tucker Carlson got that same ruling in the Playmate case, and then Rachel Maddow's got that same ruling in the Newsmax case, where it was like, hey, these are just opinion shows. It's for entertainment. No reasonable person would think that they were saying, the truth. So I was like, oh, wow.
The reason people on the right side thought that there was a distinction there is because of the specific words that were being used. Meaning, Rachel Maddow used the word literally. So she said, like, he's literally, I don't remember what he said, a thief, like literally a thief. And the court was like, when she said literally, she meant not literally. She meant figuratively. It's like
she meant literally in the Flighty Valley Girl parlance, right?
Yeah,
no,
I guess.
Literally
does not mean literally.
Just to be clear, Tucker Carlson said it was literal extortion. He said this was extortion. I don't understand. I can actually play the clip. He said this. He was like extremely confident about this is extortion. Matter of fact, I think they even copped that it would be defamation if he wasn't on an opinion show. So yeah, his was extremely like straight up, like, yeah, this is extortion. I know it's extortion, blah, blah, blah. I don't know why Trump is not saying it's extortion. So he was very, very, so in both cases, they were very powerful in their stance of, yes, this is what it is, but they're in an opinion show. So it just,
and then just to maybe as for some extra credit here, do the lack of credentials in the legal field inure to those respective anchors' benefits in this case? So Maddow and Tucker, respectively, if they were licensed attorneys working in those same positions, do you believe that the court would have taken different paths?
Well, I think in both particular cases, it was the environment that the speech was being said on. So in this environment, if they were on a newscast, for instance, and they were lawyers, you have one thing that you can say, okay, well, at a newscast, more reasonable people would think that those are facts, versus on an opinion show, then people are going in for opinions. You're a murderer, you're this, you're that. So less likely than people.
And the lesson of this is that the court thinks that Alex Jones is a very serious journalist.
Yes,
of course. And I'll leave it alone. I think what I was asking is sort of like extortion is a term of art, right? It is a legal conclusion. There is a finding of culpability leading to extortion, and then the word literally has a has a dictionary meaning. So even if you are in the context of an opinion show, because this is right now this is an opinion show, right? We give our opinions, but there is a recitation of facts. There is a common body of reference that I think that we, as sensible humans, have to have some overlap on before we can even have a conversation about it, right?
Yeah, that's true. That's an excellent point.
Anyway,
well,
like I said, I'll leave that alone.
Let me do this. I'll just play the clip because because since we have the clip available, I think it just makes sense.
Dr.
So even the audience can see it. So here, claims are false. I had to make sure I didn't put it up.
Remember the facts of the story. These are undisputed. 2 women approached Donald Trump and threatened to ruin his career and humiliate his family if he doesn't give them money. Now, that sounds like a classic case of extortion. Yet, for whatever reason, Trump caves to it, and he directs Michael Cohen to pay the ransom.
Well, first of all, we don't know that there was actual extortion here. We know that a payment was made. There was a catch and kill deal with the National Enquirer. Whether or not it was extortion, that hasn't been proven yet, nor has it even really been alleged in many cases.
Well, I'm alleging. Let me just stop and say I'm alleging it because it's obvious. You're not going to pay $100 grand or 150 or 200 grand to someone unless there's a threat to you and your reputation. This is extortion. Now, I don't know why it's not being prosecuted. I don't know why Trump isn't defending himself on those grounds. I would, but it clearly is extortion.
Well, there it is. So what do you think?
What up, Nate? And Nate.
That's me. Yeah, that's old me. So what do you guys think? Extortion. So that again, that's what he was saying. He made it very clear he was talking about extortion.
So I believe I've discussed this before, but there's also, I think, sort of an undercurrent of this practice of shopping stories that the public largely does not know occurs all over the country. Your favorite news outlets are shopping stories and paying people money for their stories and stuff like that. So I think that perhaps Tucker, in his experience and his wisdom and knowing this undercurrent with probably far more intimate familiarity than even us as practicing lawyers, probably was making, I am alleging that because he probably knows it for what it is, generally speaking. It is some sort of just, shrugged off systematic extortion scheme that drives these stories in the media, right?
Mm-hmm.
But
no, I agree 1,000%. I just
what is the legal definition of extortion that was failed to be satisfied here?
Well, I don't even think they got to that question. Right?
They didn't get to that question because they said he's on an opinion show. He's giving his opinion, so it doesn't matter.
Right, it's true.
Yeah, it's an opinion show. He's saying
you have the Rachel Maddow clip also. You don't have that.
Yeah, the Rachel. Hold on, I think I have the Rachel Maddow clip. I'll pull it. But hers was just as definitive with Newsmax. Hold on.
MSNBC.
Yes, the MSNBC Rachel Maddow clip. Matter of fact, let me move on to this other story, and I'm pull the Rachel Maddow clip.
Is this true? SD Trekkie Girl says that Miriam added a second definition of literally that means figuratively.
Yes, that's true.
Wow.
Yeah, literally now means
Maddow definition.
Mine. It is rough out here.
Welcome to a post-truth world.
Yes.
Informational dark age, I think I call it. Everything is.
Oh my God! Yeah, that it's this is where it is. Let me see.
Yeah, Brian, I think I would agree. It's like by that same logic, it's like maybe Miriam adds another definition to racist, which means figuratively, right?
Yeah, literally. But that's because a lot of people use literally to mean figuratively. It's a weird little thing, but yeah, it's one of the ways it can be used.
Hey, people are like, I'm literally dying.
Let me move on because I'm looking for this story, but I gotta find it. I'm literally dying. Oh my God. All right, so boxing, Olympics.
Okay.
Biological man. This person has an XY chromosome and is fighting in a gold medal game. It was all hell breaking loose. Now, for those of you who don't know the story, this person, Imani Khalif, is from Algeria. In Algeria, it's illegal to be trans. You get 3 years in prison, and they don't play the birth certificate game. When you're born, they look at you. If you're a man, put male, women. There's no, you get to pick it. They go to the Olympics, win, come to find out, they took a test, a genetics test, and the test was just to see what their chromosomes were, because the the Russian Boxing Federation was afraid that you could have men impersonating women and winning gold medals. So they said we're going to give a specific test just to see what your chromosomes are. Allegedly, they gave this test to this person and found out this person had an XY chromosome. This person is someone else. So they banned them from boxing. The Olympics then came back and said, no, they can box in the women's category. Now, this person allegedly has a disorder. There's a couple. There's one's called Swyer syndrome or DSDs. Now, these disorders are when someone who has an XY chromosome or an XX chromosome, you develop with the opposite sex organs. So you have women with XY chromosomes who have women body parts, but just have this chromosome, and they don't go through male puberty. And then you have men who have male parts and go through male puberty. So the issue now is, should this person be allowed to compete at the Olympics? Because this person didn't transition, didn't do anything. This person it's considered intersex, does have all the female parts, but does have an XY chromosome. So obviously half the country is saying obviously no. Now, my position on trans athletes, men competing with women, it's ridiculous. I'm just going to, I don't know how plain I can say it. It doesn't make sense to have, but we know men are faster, stronger. We know, we've known this forever. And matter of fact, we have laws to protect women's sports like Title IX, because if women were forced to compete with men for athletic scholarships, they wouldn't win anything. There would be no women's sports. So I do understand that if you're a man, you should not be competing with women. But in this particular case, allegedly, this person, the only thing that makes this person a male is the XY chromosome. So does that, there's no definitive proof that this person has any advantage over women, because they don't have, even though this person to me looks like a guy. But then second part of it is, what exactly is it just your genitals, what you have, or is it your chromosomes? So that's the controversy now. I don't know if you guys have an opinion on this particular topic.
Well, I'll start with maybe an uncharitable one. But how do you spell the name Imane?
I'm Imani. I am Imani. I am A-N-E. Let me pull it back. Put it back on.
Man.
Yeah, that's Joe knows.
I'm Manny. There it is.
Imane.
Yeah.
Imane, right? Anyway, that's just, look, it's a terrible joke, but it's also right in front of us. So I think that this is an interesting fact pattern. I think but it's being lumped into what we've been discussing here domestically, especially in the case of swimming and other stuff. So it's sort of like this is an outlier in that conversation. I actually don't even know how to go about analyzing this fact pattern just based on the biological realities of the person who is, being subject to the criticism. I don't know what you tell someone in that position in their formative years, or what the obligation is when you're born intersex as to how you choose your path to competition, right? Like masculine.
It's very easy. Go the harder route.
Okay, I believe that, just at a personal level. But is society? Is that what society is supposed to do, to say, hey, you go with more adversity than less?
Yeah.
Okay.
That's kind of it. I don't think. See, that's. I mean, I don't understand this. So it's like people will say, but that's not fair because Imani, is female and can't compete with the men. It's not fair that I never had a 36-inch vertical leap. That's not fair. That's not fair. No matter how hard I would try, it's not fair. I mean, just because your body doesn't enable you to compete at a level of sport that is being designated for you doesn't mean now we're going to have to change the rules of the sport. It means you're just not equipped to compete at that level with those types of persons. It's really very simple.
I think that's right.
I mean, it's really not even, it's not that confusing. It's just like, look, you have to go the role of adversity because you have an unfair advantage. If you're like, in other words, someone is a 1 or a 2. Well, this is a 1.5. Okay, well, you know what? You're too high on the threshold for here, so we can't let you in here. If someone has a weight problem, and so in that case, we have different boxing divisions based on weight class. So you're going to say, oh, okay, well, we're going to let this person who's a heavyweight compete with someone who's a middleweight, or you know, welterweight. It's like, what are you joking? Like that, but it's not my fault because I have a different biological issue with me where I retain more fat or something like that, and that's the only reason I have it. So, okay. Well, since you have that biological issue, we're going to let you go in there and just pound on someone who's 30 pounds lighter than you. That makes no sense. It makes no sense. I also
saw, and I can't verify this. I largely agree with you, Joe, and I like the round up. Sort of like, I guess the phrasing is you round up because you went to, is it 1 or is it 2? It's 1.5. Well, I think we were all taught in fundamental mathematics that you round up, right? And depending on how many decimal points, but just
they might try and come back and say, well, mine is only 1.2, not 2, not 1.2.
Right, but I think your point just more plainly is right. Well, the precedent that we would set then is actually encouraging more of this sort of confusion or whatever else, and we don't need to do that, right? It's a pretty simple issue on balance. I agree. I also saw something, however, about the competitor having supported a lot of the trans stuff in favor of the opponent.
But
I can't.
Well, 2 things. One, the opponent, she quit before another boxing match, so this was like the first match she quit on, and so it was like, you know, even though she quit 46 seconds, she's done this before. And also, Imani has lost against other women. In 37 fights, she's got 9 losses, and there's only like 5 KOs. So the physical advantage, people are not sure that she actually has that physical. Like, for instance, like Leah Thomas, who was a guy who went to Penn State, who was on Penn State swim team, woke up one morning and said, I'm going to be a woman, took hormones for a year, and then started racing against the women, right? And then was a top woman in the world, but then was like number 600 as the man, right? That's ridiculous. That I think is the fear. But in this particular case, I don't know if this person has an advantage, but I would, like Joe said, I would rather be cautious than be sorry later, where this person to kill somebody and be like, oh my God, I didn't know. You know what I'm saying? So I do, especially in combat sports. So I am more sympathetic to that. But I think it's just not as clear cut as we'd like it to be. You know, XY, it's automatic, but this may be a situation where it's just not as clear cut. So
I think Joe's position inures to the benefit of like long-term civility and polite society. I think it upholds the standards that we strove for and established in the West. So I'm on that side. I think that it's also important that we think about what young people are learning in their formative years and what they're absorbing from these conversations. And I think in general, there should be black and white decisions made on these issues. And I also think somebody in the chat was making somebody in the chat was making the point that it scrolled by me, but making the point that men's sports are technically open to everyone. Women's are reserved for women's. And I think that's accurate as well, right? I mean, I remember playing, teams in high school that would have, for example, like a female place kicker on the football team or things like that, right? So that was, it wasn't common, but that was within those exceptions or, sort of rare occurrences. It wasn't ever the other way around, right? You never had sort of a male forward on the women's soccer team or anything like that, right?
Yeah. That which
in midget basketball, you can't be a certain height. It's like, well, it sucks that you're a midget and you have to be a very tall midget, but it's like you have to have a cutoff, and it's really not even. This is not something which is. I don't think where the opinion that Mike and I are coming to here is at all controversial. It's just
no. It is good. Like I literally have been arguing with people about this because like my top video is about the trans guy who went and won the women's world championship for weightlifting. It's 8 million views because it was ridiculous. But there's a whole bunch of people who says I'm transphobic for standing with the proposition that biological men shouldn't wake up one day and compete. I can still bench press almost 300 pounds, and I'm not an Olympic athlete. But the woman who won the world championship can only bench press 270 pounds, right? So that's crazy. That's crazy.
Well, and also, I mean, maybe this illustrates something, and this is just me being selfish and moving this back into sort of the administrative and regulatory context, but it's sort of like a, we could spotlight the failures of local politics and sort of the averageness, as I'll call it, of these lower level political bodies or these bureaucratic bodies that are responsible for handling fact patterns that they themselves are not competent or equipped to handle in a way that I think that we would be proud of, but they also probably feel this like cultural pressure around them. So yeah, I think somebody asked, why is the IOC pushing this trans stuff? I don't know that they are quote unquote pushing it insofar as this issue has matriculated into their custody far, like a long time before it's an actual issue for us as a society, because it's being put on the world stage during the Olympics. I mean, these are local athletic associations at a small level being confronted with these weird fact patterns of like, well, what decision do we make? And acting in their own self-interest so as not to be ostracized for being bigoted or ignorant or transphobic or whatever else it is. I mean, these are average people in average positions, which is, again, sort of my call to say, if you care about this stuff, just be involved in your community locally, in these small levels. If you feel like you're a responsible steward of these conversations, the way to get back at it and to right the ship is for reasonable people to find their way again back into local politics.
Just one point that I left out, which I should have made mention, is that the rule in the Olympics is that if you have gone through male puberty, you cannot compete in the women's category. So any person who's gone through male puberty, that's kind of their cutoff. And that's the issue with this boxer. Did this boxer go through male puberty? And right now the convention is that the person didn't. So that's why they're allowing them to compete with women. But the cutoff now at the Olympics, so that was like a big controversy because they said that's transphobic because, if you're transgender, and then they say that, well, then you should allow kids to transgender before puberty, but then you have a whole other issue with how do they know that they're transgender before puberty? So that's the issue now. But the rule in the Olympics is generally, if you go through male puberty as a team, you cannot compete with women at the elite level.
I want to ask you guys a question. Do you think there's a difference? You referred to combat sports.
Yeah.
But I wouldn't make the cutoff combat sports. I would make sports where you're interacting with each other rather than alongside the other. In other words, if you want to try and make that line at combat sports, which I think that the reason we would draw a line at combat sports is because we're genuinely worried about the safe and healthy of the participants.
Well, hold on,
I say any sport.
Yeah, no, just to clarify, yeah. I'm not saying my cutoff is not combat sports. It's any running, track, whatever.
Yeah,
if it's men versus women. It's obviously.
I love you because you just like, to me, sports is meritocratic. Yeah. Right. And anything that we're doing to talk about other factors other than merit on the playing field being having primacy, I think is a treason to athletics, generally speaking. Right.
I'm just
built on merit.
To get philosophical, for 1 second before we leave this topic, I want to make the following point. There's really two problems here. There's maintaining the integrity of the sport, and then there's the health and safety of the athletes. Yeah, right? Correct. Those are two different problems. And the point I wanted to make is, those who might raise the issue of only it should be different in combat sports, I would point to the volleyball girl who's paralyzed now, right? Crazy, and that's not volleyball is not considered a combat sport. The point is that if it's any sport where they're coming in contact with each other, that should be qualified. When we're worrying about the safety of the athletes, that has to be qualified. So if it's baseball and you have some dude who's going to be hitting a ball much harder, or any sport where it's not necessarily to bludgeon the other person like boxing, but there's any sort of engagement between the participants against each other, that's where the added element of a safety concern has to be brought to the forefront, as opposed to swimming, where there's no threat to Riley Gaines in getting into a pool against Leah Thompson that she's going to be physically harmed by Leah Thompson. But there is the integrity of the sport that's being thoroughly decimated by having that added participant. That's the point that I want to get at.
That's actually a very astute point. There are a couple more stories that we wanted to go over, but I'll try to run through a couple of them quickly. First, Ashli Babbitt. For those of you who don't remember Ashli Babbitt, she was the
And Nate,
January...
if I may, I'm gonna bow out here.
Oh, okay, cool.
I'm redlining. But Joe, always great to see you. And
You
Nate,
too,
I
Mike.
hope to see you again soon. All I'll say is resist court packing. All right, see y'all.
Amen.
Thank you for having me.
Later, brother.
Thank you, brother. All right. Well, this is the last story of the day,
and this is a good one for me. I covered the complaints on this one.
So this is the Ashli Babbitt wrongful death suit heading to court. So they just filed their lawsuit. Did they just file, or they filed they just filed this lawsuit, right? Or has it been filed and it's going through the court? Joe, since you've got it, you want to...
Yeah. So this thing was actually filed back, I believe 3 months ago. It started in California, and they successfully changed venue over to Washington, D.C. So the reason it was filed in California is because Ashli Babbitt was from San Diego, and they initially tried coming into federal court in San Diego, in the Southern District of California, and it got transferred. Venue got transferred over to D.C. And you can understand why, if you're the plaintiff is the one who chooses venue. They're the one who filed the complaint. The defense has an opportunity to change that venue over and make the argument to the court that there's a better venue than this one. And so as much as I'm praying that Ashli Babbitt's estate and her husband succeed in this lawsuit, I cannot deny as an attorney that it actually does make sense for this case to move to D.C., especially
circumstances.
Because, there's a lot of different factors they look at. And whenever you have a lot of the witnesses coming from one place, that's going to be a factor. Also, if you're talking about an injury to someone, the site is usually of the accident is usually the predominant factor. So if you had someone from Oregon driving cross country to New York, and they get into an accident in Missouri, frequently, and neither person is from Missouri, frequently it will end up in Missouri because that will be considered the dominant element to determining venue. So this did get moved over to DC, and that's definitely a relevant factor here. As bad as a venue as California is for someone who's a person injured for being MAGA, that DC is the worst jurisdiction, in my opinion, for a MAGA person who's injured on January 6th to come in there. Because I've been down in DC, and I'll tell you right now, a lot of people watched the J6 hearings. I was watching jury selection, one person after another coming in. They TiVoed that thing. They were so all over. The jury pool that she's going to have there is terrible. So I want to just start with that premise. And the judges there were like literally affected by J6. Everyone who is in DC living there seems like they were just like they have like PTSD from it. So in that sense, I think it's a terrible venue as far as being fair to the plaintiff. But traditionally, that would be the right venue. Anyway, the objective here in this complaint, now that I explained to you where they're located and why they're located there, I can talk to you a little bit about what the complaint is. And essentially, they're suing the United States of America because whenever you're suing a federal officer for doing something wrong while acting in their official capacity, you don't sue the individual. You don't sue even the triple letter agency that they're working for. You don't sue the U.S. Capitol Police. You don't sue the post office. You always, and the United States of America is the named defendant, and they're considered responsible for the activities of their employees who are working in the context of provided they're working in their capacity as being an employee rather than just driving down the street one day. So the United States of America is defendant, and what they're claiming is that the lieutenant who shot Babbitt was either intentionally, and it was either an intentional act during the course of his duties or thoroughly negligent, leading to the wrongful death of Ashli Babbitt. And they cite so many different ways that he as an individual was deficient and negligent in what he did and practically criminally reckless when you look at what he did. and that the United States of America and his supervisors were negligent in leaving him in that position, that this guy has pulled his gun multiple times before where it shouldn't have been pulled, and that he basically was a reckless individual who was put into this situation, never screamed out a warning. She had absolutely no way of knowing that she was even going into physical harm's way from someone defending the place. That there was no one from Congress who was still there who he was defending. It's not like that room was uniquely special. That right behind that door is Nancy Pelosi or some congressman whose life is endangered, and that even he shouldn't have unholstered his gun. They cite so many different negligence elements. He shouldn't have unholstered his gun. If he was going to unholster it, he should have kept it in a low ready position. When he pulled the gun out, he's waving around and basically at multiple different people and ignoring the people who are not actually even trying to breach in, but just on the other side of the door. He's just sort of waving the gun around like a lunatic, ignoring the fact that there are police officers in the hallway with her, overestimating how big the crowd is, saying that there were hundreds of people when there was likely somewhere between 15 and 20 people, and at maximum 30 or 40, and that they're negligent, and that the other police officers also, you don't need to get his negligence if you're Ashli Babbitt's family, that the other police officers who were right behind her did nothing to try and stop it, as Ashli Babbitt herself was saying, this is a dangerous situation. You need to step in here and control this crowd. And that the police officers behind her basically like, nah, you guys do what you're going to do. So she herself, which is it's unusual circumstance, but according to the complaint, she herself is the one who actually called to their attention. This is a dangerous situation. You should try and stop this thing from happening. And she's the one who actually ended up being a victim. As far it's interesting complaint to read in that they go through the timeline of her day. So we learn a lot more about Ashli Babbitt's experience on January 6th leading up to her shooting. And they point out that when she was shot, that she actually went through pain and suffering, unfortunately, which the reason they bring it up is because it's a greater compensation for that pain and suffering. And that's it was a couple of minutes before she actually passed out, and that it took her I think close to an hour before she died. But that there was negligence in the treatment afterwards. Well, and when you look at it, I'm landing my plane, and I know I've been going here for a while. But that when you look at the whole comprehensive package here, there's a number of different elements which you can really point to as far as where there was where there was different levels of negligence that resulted in her death. To me, the worst one is him waving that gun around rather than even to pull the gun out. I'm trying to picture myself in this situation. There's a massive crowd of people there. You're scared that you want to defend the people who are in here, even if they're not, protected Congress people. And you don't know, how, and you don't know if they're armed or not. You have to sort of put yourself in his shoes to see, is he acting as a reasonably prudent police officer? That's the standard of care that you have to cross. You have to show that there's a breach, that there's a duty, and that there's a duty of care, and that he has to act. There's a certain protocol, and that he deviated from that protocol, and it's a result of that deviation that led to the injury. That's what they need in order to have a valid claim here. So I think that if you look at this objectively, there is a very strong reason to be hopeful for this case having success in an objective perspective. But the reason I started premised with that whole venue thing is because I think that the jury that she's likely to be facing
is not going to be favorable.
Is going to be so ridiculously tilted against Ashli Babbitt that I think her hopes of getting anywhere near the 30 million or anything like that, or even getting a verdict in their favor at all are dismally low. So, that's just the reality. But now that I covered pretty much.
But no, I think you laid out the complaint perfectly. But you know Andrew Bronca, right? Law of self-defense.
Of course.
I agree with his assessment of this case 1,000%. He believes Ashli Babbitt's shooting was 100% justified. He believes that the officer did the right thing, and he took a lot of heat for it. And he still, to this day, believes that she will not get paid. And I believe his assessment is correct. Now, I can't show you the shooting obviously, because it's a shooting. But what I can show you is the person who actually caught Ashli Babbitt when she died. He gave an interview right after the shooting with actually her blood on his shirt. So this is a present sense impression. It overcomes the hearsay thing because he's literally right after the event. He's just giving his thoughts right after the event. So I'll let you.
Not sure I agree with your legal assessment that an hour later would reveal is still present sense impression that
it's not an hour later. That
would overcome hearsay. I'm not sure I agree with you on that one.
No, well, but he got kicked out. But this is literally he's like what just happened? He's got the blood in the thing. So I'm not sure if it's an hour later, but this was right after because they had been kicked out right after the Ashli Babbitt shooting, and this is the reporter talking to him. So this is the person who attended to Ashli Babbitt, literally caught her, and has Ashli Babbitt's blood, and he's going to describe exactly what happened, what he believed happened, what he saw, what he witnessed at the particular time. Because obviously the complaint's going to be favorable to Ashli Babbitt. I would write it favorable to Ashli Babbitt. But here is the person.
Your first and last name and where you're from?
Yeah, I'm Thomas Barani from New Jersey.
Can you show us your hand?
Yeah.
How did you get that on your hand?
Well, we had stormed into the chambers inside, and there was a young lady who rushed through the windows. A number of police and Secret Service were saying, get back, get down, get out of the way. She didn't heed the call, and as we kind of raced up to grab people and pull them back, they shot her in the neck, and she fell back on me and started saying she was fine, it's cool. And then she started kind of like moving weird, and blood was coming out of her mouth and neck and nose, and I don't know if she's alive or dead anymore.
And how did you get back out of the building?
Riot police came in and started ushering us out with their stick.
Where did you enter the building and where did you exit?
Other side with the scaffolding.
Now, the issue that's going to come down to Ashli Babbitt is that this cop was protecting an area. And the area they were evacuating, the cop that shot her.
Oh, the cop that shot her.
That cop that was protecting, when you look at it, the cop was protecting the area. And the area behind him, you can see Congress people being so swift sorted out. They broke their window between them, the door and the window. They had screamed. And as he said, they were saying, get down, get back. They broke into that window. And they gave warnings. Do not come through the window or we will shoot. And Ashli Babbitt came through the window. So now this is why law of self-defense claims that this was Andrew claims that this was not only a good shoot, this was a justified shooting based on the circumstances. And I agree with them. Now, the standard for this justified shooting comes from a case, because this is a Fourth Amendment claim about a search and seizure. It's called, the case on point here is called Graham v. Connor. I analyze it all the time. And the Graham v. Connor case was essentially about how a reasonable officer acts in certain situations. And in this particular situation, you look at generally three factors: the nature of the call. Here, the nature of the call was you have rioters coming in, you have a door in front of you with a window, and police have guns pulled behind the window telling people, do not break in, do not break in. The second thing is whether the person was resisting arrest, obeying orders. Here, they tell the person, don't come in here, stand back, don't break. The person breaks the window and then tries to come through. So the person is resisting police orders. And the third one is, was there a serious threat? Well, we have rioters who are breaking into windows, you have Congress people behind you that you're protecting, you have guns drawn on them, and they break through and one tries to jump through the window and he shoots. So with the facts presented and from the video, because again, just look at the video and the witnesses, this seems like a justified shooting. And again, if you call me a lefty, you can. But Andrew Branca, who is the self-defense guru, he's forgotten more about self-defense than I think myself or Joe will ever even know. He's the one that says this is 100% a justified shooting.
Okay. Now, with that, I let you go on there while I was sitting there disagreeing with a ton of things that you were saying. But I didn't want to be rude and interrupt. But I have a lot of thoughts about what we watched over the last 3 to 5 minutes. First and foremost, what this guy says to me is much less important than what is actually on video. What memories get very quickly clouded, and there's a lot of confusion, especially after you're engaged in a traumatic situation. That his testimony is kind of weak in the sense that we know she was not shot in the neck. She was actually shot in the chest. So when he's saying that, he's giving his perspective of events, that doesn't mean it's close to reality. And I think that the video itself gives us a far better view of reality as to what was said and what actually happened in that moment, far more so than this individual, who I assume is trying to be honest. But there's been countless studies which basically show how easily our memories become compromised in the best of scenarios when something is happening very quick, like in a bam bam type of thing, and that people sometimes will even get the gender of the perpetrator wrong and the race of the perpetrator wrong and their clothing wrong. So when he's saying what was happening there in the moment, I think that should be taken with that should be strongly discounted compared to what we actually see on video. So it's unfortunate that on YouTube we can't see this video, because they'll just bring the stream crashing down. But I think so. What he says about it is relatively inconsequential to me. What's far more important to me is what that video says. They claim that there was no warning that they were going to shoot. That it's like they said, "Don't come in here, don't come in here." That's different than saying, than giving a warning of saying they're going to shoot. I also don't know if Andrew is aware of the various different things that he was doing that the plaintiff alleges, and I don't know that it's true. I'm just telling you this is what the complaint alleges, which says that, and that if the allegations were proven true, to me there are levels of negligence which I don't know how this plays in. Like if your self-defense comes and there's negligence that's involved in that self-defense, whether that retains its status as being justified self-defense. In other words, does that wash away anything here that when there was negligence leading up to the situation? Meaning, let's put it this way, okay? Even if let's assume that I'm going to defer to Andrew, because you are correct that he knows far more about self-defense than I know. That even if this was a justified shoot by the time she goes in there, are still multiple elements of the negligence and wrongful death that precede this, which would be which don't make the justified shoot now wash away that negligence. So, for example, if the police there, which supposedly there were 4 to 7 police officers in the lobby on the side of the door with Ashli Babbitt, and that if they failed to try and control the crowd, and that's what leads to this entire thing, even if she ends up breaching, I still think that you can say that negligence by them is what lets this scenario unfold. Now, the defense with the United States would defend and saying, well, this is an intervening act, and that the intervening act should curtail the negligence that preceded it. What I'm saying is, even if he's right that it's a justified shoot, even if he's completely correct about that, that still doesn't mean that there's not a wrongful death claim, a valid wrongful death claim here, if this were viewed by an objective jury. Does that make sense to you, that you can have a justified shooting, that there still is negligence that would lead to warranting a verdict in favor of the plaintiff?
Well, I'll say that there are two standards, but the first thing to just dismiss, like, here's the guy, here's Ashli Babbitt climbing up to go through the window, and that's the guy who we just saw the interview right there below Ashli Babbitt. I think to say that you can dismiss this eyewitness's account of the event because he maybe said she got shot in the neck, which she's really shot in the chest. I just think is just very, very favorable to the defendant, right? Because he literally catches her. He's really right there. He says that there were no warnings. He says that they were telling her to get back. So this is damning for their case. Obviously, if he testifies, it's going to be damning for their case. Now, you may not put a lot of stock into it, which I understand. But I think a reasonable person seeing the video that is right there is different. Also,
and by the way, that's a question that you are. I would agree with you. You're correct that that's a question of fact of credibility. Like, what do you believe? What do you believe? And I'm just saying the video to me is more compelling. But you are correct.
Oh, yeah, the video is compelling, but he is in, like, him being in the video catching Ashli Babbitt. I think it's powerful.
And he is there in the video. I know he was there.
Hold on. But the second part is that when the claim was that there was no Congress people back there. Well, early in that video, you actually see the Congress people back there and actually identify some of the Congress people back there in the video, because I did a workup on this. So there were Congress people behind this cop before he fired his weapon. So what I think is that I do
the
understand.
Congress people who were there decided to stay there to help
They
fight
were
back.
being
in other
evacuated.
words, according to, if you believe the complaint, and if you give the complaint, full credit, what they say is that a handful of Congress people said, had military training or something like that and decided to stay there to help the police protect the building, but that Congress itself had been evacuated by that point, and that anyone who wanted to leave had been able to safely escape the building without being in harm. So you might be able to identify someone in this picture here and say that's Congressman X, and I'll say to you, if that is Congressman X, I believe you. That congressman chose to be there because the rest of Congress had ample time to flee.
And all of those staff members, I understand.
Nobody was there. What I'm saying is nobody was there in that room against their will. At this point, nobody there is against their will.
Well, they're being evacuated through the back entrance. And this is the way, and this glass door is stopping anybody from coming because now you have a crowd at the door and they're stopping the door. So now because again, you said the video. We have the video. We see the congressman and the Congress people's staff there, unless you're saying all those people are combat veterans, but you have all those people there, and the police are the barrier between them coming to get to those people and the mob who is inside the building. So I do understand these are bad facts for Ashli Babbitt, but the video, I'm saying I don't think the video lies. I think there were, if they're saying there was
you want to share that link with me? Which one? I don't know which.
There were people back there. There were Congress people back there. If they're saying that they weren't giving warnings, well, you have an eyewitness who caught Ashli Babbitt saying no, they were giving warnings. And then like all these little things, I think it's right there on tape. Now, I do agree. Now, if what you're saying was true, I would agree with you 1,000% that Ashli Babbitt was murdered and this is a problem. But based on the facts, the video, and the eyewitness testimony that we got available, I just don't believe you can. I don't believe a reasonable jury would come to a reasonable or objective jury would come to the conclusion that this was an unreasonable shooting. But I do think the point that you made about it being a justified shooting versus liable for civilly, that question is the question, because I don't think criminally this guy can get touched. When you're talking about civil liability, now you maybe have an argument. But I think based on the facts that we know from the Ashli Babbitt shooting, again, don't trust me, anybody. Go look at the video yourself. Go look at the facts yourself. You'll see it for yourself. It's hard to deny that Ashli Babbitt put herself in a very anonymous position, and and I'm going to say it, and I know people are going to be upset. This is a FA and find blank and find out. If I'm sitting there and they got people there evacuating and there's a door in front of us with glass and I break through the glass and jump, and they got people with guns pointing at me saying, "Don't come through the glass or we're going to shoot," and you go through the glass, she tried to call their bluff and they weren't bluffing. So unfortunately, I think that's the Ashli Babbitt story in a nutshell. But again, I think reasonable minds can disagree on this. Again, I generally disagree with Andrew, but I think Andrew on this case, I think he's convinced me, and and I think he got us on the facts. So, but again, it's not about even what we think. It's about what you guys in the audience think, because you guys are going to be the jury, right? Does Joe have the better argument? Because the complaint is written in a very, very strategic way, and I think it's a very good complaint. And I do think civilly there's an argument. Or do you think I have the better of the argument, or Andrew? It's all up to you. But Joe.
But I will say this, I just want to wrap with this. Well, the reason I think that this has significance, this case has significance, is because I do think that it's being conducted by Judicial Watch. The plaintiff attorneys are Judicial Watch, which is an organization which is designed to basically try and expose corruption in D.C. And I think that hopefully, at the very least, this will give us a more fleshed out view of facts that the government may not want us to know about, related to what happened on January 6th, because they are going to have, unless this is dismissed, unless this is dismissed on a 12b6 issue that they're saying, failure to state a cause, and you get a pre-discovery dismissal, they're going to have discovery, and they're going to be able to demand and compel the government to turn over a great deal of documents, which the government seems to have been reluctant to turn over. So to me, that's the more likely upside for Ashli Babbitt on those who mourn her passing, and then the likelihood of them getting any sort of financial relief, because I think that they are ultimately, if they go to trial, if I'm the United States of America, I'd be like, there's no way they're winning this case. I'm not offering them a dime. And I think that politically they don't want to offer a dime. And so I don't expect them to receive any sort of settlement offer. And I think that the jury here is literally, they're going to have a PTSD jury, which is going to feel as if they were inside that room themselves and very strongly pro United States in this case. So I don't want anyone to think that I think that she's going to win. I think I think this case is pretty much dead man walking, even if she's right. But I do think that hopefully we'll get discovery and find out more about the negligence and perhaps willful negligence of the government in the way they handled January 6th together. So.
Yeah, oh yeah. Don't get me started on January 6th, because when it comes to January 6th, I agree with you 1,000%. I think the government was totally negligent. And I think that's the argument that I think that could be made, is that because of the government's negligence, we only have some 5 people there to hold back 10,000 people. That kind of facilitated this. But again, it's one of those things where you got to kind of just wait and see. Well, with that being said, please join us next week.
You're going to go through the chats or
the super chats? I thought I did. Well,
you just pulled them up?
You know what? I generally pull them up here. All right, but we can go through them, because actually I don't have that much time.
If you don't have time, so in that case, we'll just land our plane here.
Let me see. So this is LB,
right.
The missing LMPD bike. Mercury. I pulled these up already. Let me see anything we were talking about. Which Capitol Hill red lines are in sight?
Shoot on sight.
Shoot on sight. I don't believe it's shoot on sight. I believe warning, breaking window, jumping through, shot fired. I think it's a little more complicated than that. Can you use lethal force in defense of property? It all depends. Because people don't really realize. So, for instance, if I have VIPs behind me exiting, there's a place here where I say nobody comes forward, and then people break in and trying to get through the VIPs. I could use lethal force, because and you see the gun and I'm giving warnings. You will put on notice that, yes, if you do this, this will be the reaction. So, and that's what the Justice Department found in clearing the officer too, that the officer gave sufficient warning, that Ashli Babbitt ignored the official warning, and you saw the eyewitness testimony who actually caught Ashli Babbitt when she was shot, saying the same thing. They were giving warnings. She didn't heed the warning. And he literally said she didn't heed the warning. So I think if I'm the government, I think I got a good case. And I know a lot of people are not going to like that, but it just is what it is. But listen, don't you guys so much for joining us. I know people hate Lefty Nate, but again, sometimes I've got to say what I feel. Also, don't forget to visit Joe. Joe has gone over 100,000 subscribers. Thank God. Hopefully you'll be on your way to 200. What do you got coming up, Joe?
I don't know. There's a lot. There's lots in the pipe. There's lots in the pipe. There's a lot. I do a nightly podcast where I'm talking law. I'm talking politics. I'm trying to inject some humor in it. And developed a little bit of a following, thank God, 100,000. So, but it's definitely not at all. No one should think that just because the show is called the Following Program, where people subscribe, that that it's any kind of cult, because it's definitely not at all a cult type of cult. So, yeah.
No, well, I'll say this, Joe. Because I do watch Joe's show time to time, and that's the reason. That's kind of where I pulled up the Ashli Babbitt thing. Because I saw you had covered it, but I didn't know your perspective on it. I didn't watch that show. Joe's show is one of the best interactive shows on YouTube in terms of politics and everything. It is. It just is.
Thank you.
No, hey, I watch it, and I've gone on your show many times. So,
yeah.
and I think if you want to have, it is not just reading the news; it's having interaction, it's having a great time. So, if you have just a sec, don't forget to go on and follow my man, Good Logic. He's a great friend of mine, and he's probably one of the best podcasters and live streamers in the game. And our TLA is also in the section. So please visit my man Joe. There's about 1,200 of you here. Don't forget to hit that like and subscribe. Now, for me, I got to go because I got kids to feed and wives to please, and you know how that is. So, with that,
please all those wives, Nate. Please all those wives.
Yes.
All right.
I will
Thank
see
you
guys later. Thank you guys
Godspeed.
so much for being here. We'll talk to you soon.